Hello and welcome to episode 23 of the Estate Planning Academy. I'm your host, Gary DeWitt, and this is the internet's most passionate show about estate planning. Today we are talking about the state's plan for you and your stuff. Everybody has an estate plan. Either you write your own, or the state has written a default estate plan for you. The default plan for the management of your affairs while you're alive is called guardianship. Your plan for the management of your affairs if you become incompetent is guardianship. It is codified in Section 68 of Title 28 of the Arkansas Code. Guardianships take time to get done, and guardianships make your private affairs public record. Somebody, hopefully somebody you know, like, and trust, must petition the court to take over managing your affairs. Then they have to notify you of your rights and serve you notice of the court hearing. They have to meet the qualifications. They can't be an unpardoned felon. They have to be over 18, and they can't be the guardian of more than 5 other people. They have to prove you're mentally incompetent or that you don't fight the proceeding. They need a doctor's or psychologist report. And they have to be approved by the court. You and they appear in court for a hearing. And finally, every year an annual report of your finance and well-being must be filed back with the court. Guardianships have limited power. A guardian must petition the court to sell your real estate, submit to certain medical procedures like psychosurgery or removal of organs except in emergency, withhold life-saving treatment, consent to a settlement of compromise of a claim against the estate or person, borrow money. For the disposition of your estate, your plan is called intestate succession. Most people call this probate. It is codified in Subtitle 4, Chapters 38 to 63 and Title 28. It is a quite complex area of law. First, somebody must step up and start the process. And every step must be approved by a judge, which is going to cost you money and time in attorney fees. You can plan on it taking at least 1 full year with many petitions, motions, and trips to court for hearings. Every step requires a hearing, and the ones I'm going to list are just the big steps. Like opening administration, selling your personal property and getting approval of the sale, selling your real estate and getting approval of the sale, paying your final expenses and bills and getting approval to pay and file the receipts, distributing your property to your heirs, accountings and inventories, approval of accountings and inventories, distribution reports, approval of distribution, and finally, probably a year or more later, closing the administration of the estate. You don't get a choice how your estate is distributed. You don't get a choice which final expenses and bills are paid. So who gets what and how much? Your surviving spouse will get 1/3 of your money, 1/3 of your personal property, and 1/3 life estate in your real estate. That means they get the right to occupy, get the right to collect rentals, but they can't sell outright without the permission of the other owners. Your surviving children will get 2/3 of your money, 2/3 of your personal property, and 2/3 of your real estate in what we call fee simple, subject to your spouse's 1/3 life estate. For surviving minor children, the money will be held in trust until they are 18. At 18, they get a check for the full sum due, and at 18, they get a deed for any real estate. Your estate must pay any outstanding bills, credit cards, and medical expenses. Any other outstanding claims against the estate. Must pay all final expenses, and finally, it must pay the cost of administration, including lawyers' fees and court fees. Estate planning replaces the state's default plan for you and your stuff with your own plan for your affairs and distribution of your stuff. You decide who will manage your affairs and how much power they get. You decide who will manage your health care and how much power they get. You decide who gets your stuff, when, how, and how much.